Thank you, Lucy, for your kind and also informative introduction. I would like to focus on the 4 lines that are on the agenda of this panel. And in the first part of my presentation, I would like to highlight the achievements by the European Court and its case law, creating a very high level of protection at these 4 levels. If we overlook the case law of the last 15 years, it's precisely on these 4 domains that the European Court made a real difference and pushed member states to create more protection for investigative journalism, for access to information, for source protection and for whistleblowers. In my second part, I will critically comment some of the developments in the case law. I will not offend or shock, but I hope to disturb at least some judges being confronted with some loopholes in their case law. First, the positive achievements. Protection of investigative journalists and acts of news gathering. Since the judgment in 1999 in the case of Le Canard Enchaîné, Frezo and Roire, we know that a national criminal offence does not necessarily lead to a conviction of a journalist. There can be other reasons of public interest which makes that sometimes national law should not be applied, and specifically when it's about investigative journalists who are reporting issues which really matter for society. After Frezo and Roire, we had Radio Twist versus Slovakia, Dupuy versus France, and Daman versus Switzerland. Another interesting example, I think, is the case of Haldiman, where national law prohibits the illegal recording of conversations or hidden recording with cameras. Well, here also the European Court said, although the national criminal law is applicable, the journalists should not be prosecuted and convicted because they contributed to a debate of public interest, a very important added level, a higher level of protection. I could also mention for investigative journalists the applications of the European Court on Article 3, where journalists are the victim of violence and where the national states need to take extra protection. Second, access to public documents. We heard about the strong developments, and I think it's also a good example how a living instrument the European Convention is. Because if you look at the text of 1950, there are no references to investigative journalists, there's no references to the right to access to information, neither to protection of sources, neither to whistleblowers. But the court has succeeded with a dynamic and proactive interpretation to make this convention effective and practical. And so they did, and we heard the explanation by Lawrence, they did that to extend the right of expression, impart and receive information, to extend it also to the domain to create access to information, not under all circumstances, but with very strong argumentation. In that the court said, yes, those who have the information have a sensorial power. You need to share that with the community. In the cases of 2009, and it makes a total shift and compared with the last Grand Chamber judgment on the refusal of the right of access to information in Roach. I would also like to underline the case of Youth Initiative for Human Rights against Serbia, which makes clear that access to information is also applicable in the domain of intelligence and security information, and to make it clear that the European Court wanted that the access to information should be applicable in this domain. They ordered, in a very exceptional way of going one step further than just finding a violation, they ordered the Serbian state within a period of 3 months to hand over the information that the NGO was requesting for. There have been many other cases, time is too short, but the court again and again has recognized in many judgments the right of access to information by journalists and NGOs. We had to wait for the Grand Chamber judgment that we heard extensively explained by Lawrence, and to make sure that all the member states will be awake now and that there is a right of access to information. The Grand Chamber has now also confirmed it. It was not just some erroneous chamber judgments who found that. So very important. And also look at the motivation of the European Court. Gathering of information is a relevant and necessary preparatory step for public debate, and disclosure provides transparency. Transparency for improving public governance. And so these are the wordings, I would say, also in the UN Sustainable Development Goals, asking for transparency, integrity, and public governance. The third level, protection of sources. No reference in the Convention, but due to a journalist and a lawyer who tried to be very demanding at the European Court's level to extend Article 10 to protect sources. That happened in 1999, since the Goodwin case, and the Court has established some very important principles on subsidiarity, proportionality, and maybe the most important one is the ex-ante review. Police and public prosecutors can no longer look into the files and the documents of journalists. You first need a court order or a decision by an independent body. Very strong case law, also applied on cases of investigative journalists. In the case of Tillack versus Belgium is a clear example how important it is for investigative journalists to have the protection of sources under Article 10, because, as all in this case showed, at the national level, this protection was not given. And the last example on protection of sources from last year, in the case against Turkey, where the court not only again repeats its case law, but also adds very strongly what it calls the serious chilling effect for sources, for journalists and whistleblowers, if there is not a strong protection given to investigative journalists or those who work with leaks. And so we come at the fourth level, protection of whistleblowers, and the big step with the Grand Chamber judgment in 2008 in the Guya case, where the European Court said, yes, of course, there is an obligation of loyalty and confidentiality, but there can be so strong public interests that can be overruled, and that we want disclosure of information of public interest, and that is why the dismissal of Mr. Guya was considered a violation of Article 10. The court didn't give a blank check to whistleblowers. It developed some criteria based on international documents which need to be followed in order to find out whether there is sufficient reason to protect whistleblowers and to give them the rights which are referred to. And we heard also Antoine referring to the application by the Court of Appeal in Luxembourg of these criteria. We had the case of Boucourt and Thomas, again, also in the domain of intelligence information. And very important that this domain is not excluded from the rights of whistleblowers. I must go a bit further because I would like to keep some time for my critical comments. First of all, I will do that in the spirit of criticizing the law and the case law of the European Court from the perspective that institutions will perish if those who love them do not criticize them, and if those who criticize them do not love them. I will not say that I'm in love with the European Court, but you understand the perspective. There are some weak steps, let's say, in the case law of the European Court. This morning, Gil referred to the case of Beda versus Switzerland, the Grand Chamber judgment of last year, in which the court overemphasizes the obligation for journalists also to respect a duty of secrecy, for instance, with regard to criminal files. It makes it to an absolute restriction, nearly, and that is, of course, unacceptable in terms of investigative journalism, presumption of innocence that need to be respected on a much too high level. I think this is really a Grand Chamber judgment where the court should feel pity for that ever they have delivered this case. In other cases, they give a too broad margin of appreciation. We heard about the balancing test. I think in general the court is applying very good criteria to safeguard public interest journalism, but in some cases the court has left a too broad margin of appreciation, even if it was in the public interest, even if it was about public persons. Still, they left the margin of appreciation to the member states to accept interferences and violations. Also in the case of Stoll, because it was a bit sensational, there was a ground not to apply Article 10 protection in this case. I think that was also a very high threshold that they requested, because it was a sensational case, of course. Diamond Salihu, we have heard, makes it nearly impossible for check it out journalism. The wording of the European Convention makes that they shouldn't have done this check it out to purchase an illegal weapon, because that's illegal and that you can't do as a journalist, but that's precisely what journalists do when they are doing check it out journalism. Very wrong decision, I would say. And the same has happened in Boris Erdmann, a journalist who tried to disclose lack of security measures in the German airports. He makes a documentary about it. He smuggles in a weapon, no risk, no problem. The European Court recognized that there was not any risk, but still the claim on protection of Article 10 was dismissed because he had a knife in the airport, and that's unacceptable. Access to information. There I see especially some cases. I will jump to mainly one, the most recent one, Rubin versus Russia, where precisely the court requests the documents to be ready and available. And I think this is a too high threshold in many circumstances. It's too easy for the authorities to say, we don't have this data ready in the format that you request, or they are at another ministry, to be able to refuse. I think there, in the future, there could be a bit more acceptance by the European Court to not to make this a too strong criteria. Protection of journalistic sources. There are some considerations in recent judgments which implies that journalists can no longer use information by whistleblowers if these whistleblowers didn't first go through all the necessary internal procedures. So a journalist should need to check if a whistleblower has acted according to all the procedures of his or her own professional obligations. Can journalists only work with legal leaks? And that, I think, would be problematic, but it's a consequence of one of the considerations in its judgment. I must skip this one, and the last one, protection of whistleblowers. Very strong cases by the European Court, but also some very weak cases. And I would bring under your attention the case of Grigory Pasko, a man who disclosed massive nuclear waste by the Russian Navy. He wanted to hand over this documentation to Japanese media. He was arrested and convicted for 4 years in prison. And the European Court said, well, this is a lenient sanction, 4 years in a Russian prison. And yeah, he's a military man. He's under an obligation to not to disclose information. By way of conclusion, I see some loopholes in the case law of the European Court for investigative journalists. Access to official documents only when it's ready and available, that creates a problem. Illegal leaks no longer protected as journalistic sources, and no sufficient protection in some cases for whistleblowers. I think that justifies why we are here, why we need to keep on monitoring the case law of the European Court. It is important. It has helped us a lot in terms of freedom of expression, and specifically for public service journalism, but there's still a long way to go. And I end with quoting 2 dissenting opinions of judges, which unfortunately, I would say, are not quotes from judgments by the European Court itself. The media are not meant to be peaceful puppies. They should have the possibility to bark now and then and to disturb an appearance of threat. And in some cases, the finding of no violation of Article 10 contributes to the weakening of the philosophy of freedom of expression itself. At a time when the winds are changing, it is the court's task, more than ever, to reinforce freedom of expression and information as a key element in democracy. It's a quote from a dissenting opinion of Judge Tulkens, Popovic and Sayo. 2 of them are amongst us today. Thank you very much for your attention.